In 1999, the Bradley family filed a lawsuit against Royal Caribbean International. They alleged negligence, defamation, and intentional infliction of emotional distress. Royal Caribbean's response was 4 simple words: acted appropriately and responsibly. That phrase, acted appropriately and responsibly at all times, is the spine of this episode. Not because it's a lie exactly, but because it requires examination. Because appropriate is a word that depends entirely on the standard being applied. And in 1998, on a cruise ship in the Caribbean, the standard was very different from what a reasonable person might assume. This episode is not an indictment of Royal Caribbean. It is an examination of what they did, what they said, what the record shows, and what the gap between those things tells us about how a company responds when one of its passengers vanishes. This is episode 6 of our 12-part Amy Bradley series. This is Acted Appropriately. To evaluate Royal Caribbean's response to Amy's disappearance, you have to understand the environment they were operating in, because 1998 was a very different moment from the cruise industry than today. Remember, there was no mandatory reporting requirements. If a passenger went missing, the cruise line was under no legal obligation to report it to the FBI, to any federal agency, or to any outside authority. That obligation wouldn't exist until the Cruise Vessel Security and Safety Act of 2010, 12 years later. What happened in the interim was entirely at the company's discretion. The FBI's own posture in those early months reflects the same institutional gap. In November 1998, 8 months after Amy disappeared, FBI Special Agent James Weber stated publicly, "We've pursued every angle from whether there was foul play, a suicide, or an accident, and we have basically not gotten anywhere." That statement was not a failure of effort. It was a description of what the system produces when the evidence window closes before anyone with investigative authority has access to it. There was no electronic tracking of passenger embarkation and disembarkation. According to a detailed analysis published by Sail Away magazine in November 2025, examining Royal Caribbean's response to Amy's disappearance when the Rhapsody of the Seas docked in Curacao on the morning of March 24, 1998, and 2,400 passengers were permitted to disembark, Royal Caribbean had no system in place to record who got off the ship. No manifest, no keycard exit log, no digital record of departure. If Amy walked off that ship or was carried off of it, there is no technological record that would have captured it. There was no standardized crew passenger fraternization policy with teeth. The relationship between Amy and Alistair Douglas, a member of the ship's band, developed over the course of the cruise with no apparent intervention from ship management. Today, most major cruise lines have policies that explicitly prohibit this kind of fraternization and treat violations as grounds for termination. In 1998, the rules were less defined, less enforced, and in many cases, non-existent. This context matters, not because it excuses what happened, but because it explains the environment in which it happened. Royal Caribbean in 1998 was operating within an industry that had not yet been forced to confront the consequences of its own structural gaps. Amy's case, along with the cases of Marion Carver in 2004 and George Smith in 2005, would eventually be part of what forced that confrontation. The question this episode asks is not whether Royal Caribbean broke the law in 1998. The question is whether they met the standard of a company that genuinely prioritized finding a missing passenger over protecting its own operational and legal interests. Under maritime law, cruise lines are classified as common carriers. In a 2025 analysis of cruise line legal obligations, Zachary Anderson Law, a firm specializing in maritime passenger claims, documented that this classification carries a heightened duty of care, a legal obligation to take reasonable steps to protect the safety of passengers that applies regardless of whether a ship is in U.S. or international waters, and holds cruise lines to a higher standard than ordinary businesses. In practice, in 1998, that duty of care translated into very specific requirements. No mandatory surveillance systems, no overboard detection technology, no independent law enforcement, no obligation to preserve evidence pending investigation, no requirement to notify outside authorities within any defined time frame. What the duty of care did require was a good faith effort to respond, to take the situation seriously, to deploy available resources in a way that prioritized the passenger's safety over the company's schedule. The good faith standard was tested almost immediately. On the morning Amy was reported missing, Iva Bradley went to the ship's captain directly, and she asked him a specific question. What is the standard operating procedure for a missing passenger? His answer? He told her they didn't have one. There is no way to dress that up. The captain of a vessel carrying thousands of passengers, a common carrier with a documented heightened duty of care, told the mother of a missing woman that the company had no established protocol for responding to exactly this situation. Not an inadequate procedure, not one that needed improvement. None. That statement, made directly to Iva Bradley on March 24, 1998, may be the single most revealing thing anyone from Royal Caribbean said in response to Amy's disappearance. It was not a public relations statement calibrated for legal exposure. It was a candid admission from the person in command of the ship, and it defines the environment in which every subsequent decision was made. What Royal Caribbean had was a ship's captain with discretionary authority and an internal protocol for handling incidents. Those protocols were not public. They were not standardized across the industry, and their application in Amy's case is documented primarily through the Costello Report, an internal document authored by the ship's head of security, the same man who tried to strong-arm Chris Fenwick's master tapes. Lou Costello was Royal Caribbean's head of ship security aboard the Rhapsody of the Seas. He was the first company official to formally respond to Ron Bradley's report that Amy was missing. This happened outside their room. He authored the internal security report that became the company's primary documentation of its response. He was the man who called Chris Fenwick's room and tried to get his master tapes. The Costello Report is the most important piece of documentation in evaluating Royal Caribbean's response. It is also a document that requires careful reading because what it omits is as significant as what it contains. The report logs the time of Ron Bradley's first formal report to ship security, and that time has been disputed. Ron Bradley's account places his direct conversation with Costello significantly earlier than the time logged in the official report. The discrepancy matters because it determines how much time elapsed between the family's first report and any company action. If Ron's account is accurate, the response was slower than the report indicated. The report does not adequately explain the announcement delay. According to the Bradley family's meticulous records and documentation, the first PA announcement asking Amy to come to the purser's desk was made at 9:39 a.m. The Costello log itself, a document that is part of the family's records, supports this reading. By 9:39 a.m., The ship had already been docked in Curacao for hours. Passengers had already left the ship. The window for holding any potential witnesses on board had long since closed. The report does not explain the denial of the family's request to hold passengers on board during disembarkation. Ron and Iva Bradley asked specifically that passengers be prevented from leaving the ship while Amy was being searched for. That request was denied. Nor does the report reconcile the captain's claim to the family that every nook and cranny of the ship had been searched, according to the Bradley family's records, the best available on Amy's case. When Iva's brother spoke to local Curacao authorities on the island, it became clear that a comprehensive search of that kind was logistically impossible in the time available. Costello's own log confirms that the search consisted of 3 officers covering common areas, bathrooms, and lockers, while crew members searched their own quarters unsupervised. In 28 years, Iva Bradley has noted not a single passenger has ever confirmed that their cabin was searched. Not one. The report does not accurately account for what happened with the eyewitness accounts of Crystal and Lori. According to the family's records, when the girls heard that Amy was missing, they told their aunt that they had seen Amy with Alistair Douglas. Their aunt directed them to go to the purser's desk, and they went. They were taken behind the desk by ship security and questioned directly. Costello never reported in his log that this questioning took place. 2 eyewitnesses who had spent the evening and periods of time prior with Amy and Douglas, who knew exactly what both of them looked like, were interviewed by ship security, and Costello didn't deem that interview necessary to appear in the official record. The family only learned of it through their own independent documentation. What the Costello report is ultimately is a document that describes Royal Caribbean's actions without interrogating them. It is a record of what the company did, authored by the company in the absence of any independent investigative oversight. What makes this more striking is that Royal Caribbean knew, at least in part, where the gaps were. Ross Klein's Senate testimony revealed that Royal Caribbean hired outside consultants in 1999, the year after Amy disappeared, who produced internal reports identifying specific reforms. Among the items Klein noted had not been properly implemented: standardizing the response to incidents of crime across all ships, independent advocates on board available to support victims, a better CCTV surveillance with tapes retained for a reasonable period. Royal Caribbean's own consultants told them what needed to change. The record on how thoroughly they followed through is, at best, mixed. Now, we have covered Chris Fenwick's account in detail, both in episode 3 and in our first Witness Wednesday episode. But it belongs in this episode because the family's records have since clarified something important about what actually happened with the footage, and it is more extensive than that single call that we presented in Witness Wednesday. Chris Fenwick had footage of Amy dancing with Alistair Douglas in the Viking Lounge. He found it, dubbed it, and attempted to get it to the family. What the family's documentation now makes clear is that 2 parallel actions were taken by Royal Caribbean at the same time. First, Lou Costello, head of ship security, called Chris Fenwick directly and tried to get his master tapes, which of course Chris refused. Simultaneously, cruise director Kirk Detweiler called Steve Smith, the ship's own onboard videographer, and instructed him to remove any images of Amy Bradley from the ship's travel tape. Steve Smith later divulged to Fenwick that it was Detweiler who had come to him with those instructions, confirmed in a text message between Fenwick and Smith that is part of the family's records. So you have the head of security pursuing the independent footage and the cruise director attempting to scrub Amy from the official ship video. 2 separate instructions, 2 separate people, 1 outcome: the removal of Amy's image from every piece of video on that ship. Fortunately, Fenwick refused. Whether Costello's claim of FBI coordination was accurate has never been established. What is established is the sequence. Amy was reported missing. Footage was identified that placed her with a crew member during a disputed time frame, and the company's security chief moved to obtain the footage before the family or any independent authority could access it. Royal Caribbean has never publicly addressed either of these actions. Neither appears in the Costello report. The family's records document both, and together they represent something more than a single security chief's attempt to retrieve a tape. They represent a coordinated effort at multiple levels of the ship's management to eliminate visual evidence of Amy from the record on the day she disappeared. Royal Caribbean's public statements in the aftermath of Amy's disappearance follow a recognizable pattern. They are corporate in tone, defensive in posture, and designed to establish a record of cooperation without conceding any specific failure. Their initial response acknowledged the disappearance and described their support for the family. They noted that crew members had voluntarily submitted to polygraph tests administered by the FBI, a detail they returned to repeatedly as evidence of cooperation. When the family filed suit in 1999, Royal Caribbean's statement, reported at the time by Travel Weekly, was pointed. They said they acted appropriately and responsibly at all times. They said they had fully cooperated with law enforcement, and then they added something that reveals a great deal about how they understood their relationship with the Bradley family. We're sorry, despite all these efforts to assist the Bradley family, they've apparently decided to direct their grief at the company by filing a lawsuit seeking financial damages. That framing, directing their grief at the company, is worth examining. It reframes a legal action into an emotional response. It positions Royal Caribbean as the aggrieved party, burdened by a family's unresolved grief, rather than as a corporation being held accountable for their specific failures. It is a classic crisis communication maneuver. Shift the subject from the company's conduct to the plaintiff's state of mind. Jim Walker is a maritime attorney and the author of Cruise Law News, a blog he describes as everything the cruise lines don't want you to know. His firm has represented more than 2,500 clients, including survivors who testified before Congress on cruise ship safety. Walker wrote directly about Amy's case, and his assessment was precise. Like most disappearances at sea, the cruise line's investigation seemed designed to protect the cruise line's image and legal interests. And on the Bradleys' position relative to the institutions around them, he was equally direct. The Bradleys were fighting the cruise line largely alone. Before the formation of the International Cruise Victims Organization, before 5 congressional hearings, before any of the public awareness that would eventually force the industry to reckon with its record. Walker's observation is not a legal finding, but it describes the structural reality that Michael Winkleman also identified in episode 4. When the first investigators on scene are employees of the company, and the company controls all access to the information, the investigation serves one thing: the company's interests, and that's all. The Bradley family filed 2 lawsuits against Royal Caribbean in 1999. They alleged negligence, that the company failed to take responsible steps to protect Amy and respond appropriately to her disappearance. They alleged defamation, and they alleged intentional infliction of emotional distress. The lawsuits were ultimately dismissed, but the circumstances of that dismissal are not something this series can leave in a single sentence. The case was dismissed with prejudice. The stated basis was that the Bradley family had withheld information from defense counsel during discovery. The family's position, stated directly and on the record, is that this is false. The same information that defense counsel claimed had been withheld had already been provided to them in discovery. a process, it should be noted, that had not been completed at the time of the dismissal. But there's more. The presiding judge recused himself one day after the 3rd District Court of Appeals requested a response during an appeal of a motion to disqualify him. That motion had been filed by the Bradley family's attorneys, denied, and then successfully appealed. The judge stepped down the day after the appellate court's request arrived. One day, a dismissal with prejudice based on information already produced in discovery in a process that was not complete by a judge who recused himself under those circumstances. The family's attorneys argued this went against Florida Supreme Court precedent. They were not wrong to raise it. Now, I want to be careful here about what I'm saying and what I'm not. I am not telling you the outcome was corrupt. I am telling you that the procedural record of how this case ended is significantly more complicated than the lawsuits were dismissed. And I am telling you that the Bradley family has maintained consistently and specifically that the basis for the dismissal was false. They did not withhold information. They provided it in discovery. The record, as they describe it, supports that position. People have assumed otherwise for years. This episode is putting the actual record on the table. What the lawsuit record does give us is Royal Caribbean's official position stated under legal obligation. They acted appropriately and responsibly at all times. That is the record they chose to create. Iva Bradley wrote about the cruise line's response in a blog post on the International Cruise Victims website years after the disappearance. Her words were direct. To this date, the cruise line has failed to cooperate with our family by way of information or assistance. 2 accounts, 1 event, and a gap that has never been closed. To understand what happened with Royal Caribbean's response to Amy, it helps to understand that her case was not an anomaly. It was in many ways a preview. Amy disappeared in March of 1998. In August of 2004, Min Carver disappeared from a Royal Caribbean cruise to Alaska. Her case became one of the most documented examples of a cruise line's failure to report a missing passenger. It took weeks before the FBI was notified. Then, in July 2005, George Smith disappeared from a Royal Caribbean ship on his honeymoon. Evidence of foul play was found on the side of the ship. The cabin was cleaned before investigators could fully process it. Ross Klein is a professor at Memorial University of Newfoundland who spent 2 decades documenting cruise line industry crime data. He maintains a research database called cruisejunkie.com, has published 4 books on the industry, and has served as an expert witness in cases against major cruise lines. He testified before the U.S. Senate Commerce Committee on the pattern of non-reporting across the industry. His testimony described what he found in direct terms. The largest problem, he told the committee, is that we have regulations that are not being enforced, and part of the enforcement is that there is no monitoring taking place. His research showed that cruise lines' internal statistics bore little resemblance to the numbers that eventually emerged through court-ordered discovery, a gap between what the industry reported voluntarily and what litigation forced them to report. Walker's reporting on Royal Caribbean, drawing on documents obtained through court orders and separate litigation, found that the company had internal records of hundreds of incidents of sexual misconduct across a 3-year period, while publicly describing such incidents as quote-unquote rare. Those internal studies only became available because plaintiffs compelled their disclosure through civil discovery. Without litigation, they would not exist in the public record. Amy's case predates all of this. It predates the formation of the International Cruise Victims Organization. It predates the 5 congressional hearings that led to the CVSSA. It predates the public awareness that would eventually force the industry to confront its own miserable record. In that sense, what happened to the Bradleys was not just a failure in a single case. It was a preview of a pattern that would take another decade to fully surface. The CVSSA of 2010 changed the mandatory reporting requirements. It required cruise lines to to report crimes and missing persons to outside authorities. Think about that. That was not a requirement prior to 2010. It mandated the use of overboard detection technology with the qualifier to the extent technologically feasible, which Michael Winkelman flagged in episode 4 as a significant loophole. It created a public crime reporting database. Following the George Smith case, Royal Caribbean publicly stated in a comment reported by NBC Bay Area that it had significantly enhanced its policies and procedures for preventing and responding to security incidents. The acknowledgement was notable. The company conceded it could have done better, while carefully limiting that admission to a specific incident rather than the systemic pattern that eventually emerged. None of these changes existed in 1998. None of them would have been required even if Amy's case had gone differently. The industry's self-correction was not proactive. It was reactive, and it came only after cases with enough public attention to create legislative pressure. That is the context in which Royal Caribbean said it acted appropriately and responsibly at all times. Appropriately, according to a standard that the industry itself had set. Responsibly, by a definition that required no independent verification. If you have information about Amy Bradley's disappearance, please contact the FBI at 1-800-CALL-FBI or submit a tip at tips.fbi.gov. Tips can be submitted anonymously. The FBI reward is now $100,000. For more on Amy and the family's ongoing search, visit amybradleyismissing.com. There, you can also submit tips as well, and I encourage you to do it. Links to that site, as well as the Amy Alerts petition, are in the show notes. During the full run of this series, 100% of commissions through our Invisaware Personal Safety Partnership go directly to the Bradley family's GoFundMe. Get 10% off your first order using the link invisaware.com/Midnight Mystery Archive, also linked in the show notes, and support the show at no extra cost too by shopping through our Amazon link, also in the show notes and linked on our website homepage. Follow the Midnight Mystery Archive on Substack, X, or join our official Facebook group for updates. Another thing you can do that I would really appreciate is a rating on Apple Podcasts or Spotify, which goes a long way in helping us grow our audience, bring new ears to Amy's case. Now, I want to be clear about what this episode has and has not done. It has not proven that Royal Caribbean committed a crime. It has not proven that the outcome would have been different if they had made different choices on the morning of March 24th, 1998. Those are questions the evidence cannot definitively answer. What it has done is examine the record, the announcement delay, now documented at closer to 3.5 hours, not 30 minutes. The captain's claim that every nook and cranny had been searched, contradicted by his own security chief's log. The denial of the family's request to hold passengers. The disputed timeline in the Costello report, the eyewitness questioning that never appeared in the official record, the 2-track video suppression, Costello pursuing Fenwick's master tapes while Detweiler instructed Smith to scrub Amy from the ship's own footage, the lawsuit that was dismissed under circumstances the family and their record has consistently and specifically disputed. And it has asked a question that acted appropriately and responsibly does not answer. Appropriate and responsible according to whose standard, in service of whose interests? The Bradley family's answer to that question has been consistent for 28 years. They believe Royal Caribbean's response prioritized the company over their daughter. They have never received anything from the company that caused them to revise that belief. Now, I did reach out to Royal Caribbean for a comment. As of this recording, I have not received a response. However, if I do, I will be certain to share it in a future episode. Next time on the Midnight Mystery Archive, Episode 7, Seen. 4 people reported seeing Amy Bradley after she disappeared. A beach in Curacao, a bar on the same island, a woman in Barbados, a photograph on an escort website, then an FBI forensic analyst reviewed and concluded matched Amy's facial dimensions. Episode 7 examines each account what was reported by whom, and what the science of eyewitness memory tells us about what to make of all of it. This has been the Midnight Mystery Archive. Until next time.